What criteria should be met to be protected under copyright law? People who secretly take photos of the private lives of celebrities or public figures and sell it to the press are called the paparazzi. Can paparazzi photos be protected by copyright? What criteria should be met to be protected under copyright law? Korea's Seoul District Court ruled that photos taken of celebrities at drama or movie press conferences or commercial shoots are not protected by copyright law. This is due to the fact that there is no personal mark or creativity made by the photographer. The photos that were taken simply convey celebrities doing their jobs. Whoever takes the photos would get similar results, if not the exact same. Because it is a news photo only taken to deliver facts, it does not fall under the category of copyrighted works. News stories like personnel appointment, stock quotations, and simple incidents that only deliver objective facts according to the 5 W's and 1 H are not works protected by copyright. However, there are times when paparazzi photos that capture the private lives of celebrities can be protected by copyright. The paparazzi put in a lot of time and effort to take photos, and the photographer's originality can emerge in this process. If the originality of the photographer can be proven, then the work can be protected by copyright. However, you must bear in mind that even though a paparazzo's photo is protected by copyright, the problem of violating portrait rights or invading privacy can occur. What elements are needed for the work to be protected by copyright law? For a work to be protected by copyright, the work must have originality. When the work is not copied from someone else's creation, and when it embodies unique ideas or creative expressions of emotion, then it can be protected by copyright. Christian Dior sued Ash, a company specializing in footwear, for infringement of copyright when Ash launched sandals named Destiny. Dior said that Ash copied the sandals from their 2007 spring season. Ash argued that the parts of the sandal were very common, and there was no originality in the shape of the sandal, so it was not entitled to copyright protection. At this, Dior asserted that there was originality in the way the parts were selected and combined. In 2011, the Paris Court of Appeal ruled that the shape of how the leather end wraps around the ankle to support the foot, and how that part is connected to the band that hugs the upper part of the heel, and the way it is fastened with the buckle are original. The court acknowledged Dior's ownership of the copyright. Ash was ordered to pay Dior 10,000 euros for compensation for damages caused by copyright infringement and 20,000 euros for compensation for damages caused on the business. Most works are protected by copyright law. Not only literary work, music, art, videos, plays, photos, and architecture, but even computer programs are categorized as copyrighted work. In many countries, like IT powerhouses such as the US, India, and Korea, computer program work is also protected by copyright law. In these countries, the database is viewed as a copyrighted work because it accumulates as much information as possible and lets you search through the accumulated information, so it is protected by copyright. In the case of internet websites, if it is determined that a website has originality in its format, selected material, and arrangement, then it is entitled to be protected as a unique copyrighted work. In order to produce work that can be protected by copyright law in large quantities, social awareness that acknowledges as well as nurtures the author's unique characteristics and creative ideas is necessary. This is the purpose of the copyright law. With this kind of social awareness, authors will create more innovative works, and our society will be able to establish a foundation for a richer culture, in addition to industrial development.